Ladies and gentlemen, our opening ceremony is about to begin. Please stay inside the Zoom meeting and make sure to turn on your camera. Bismillahirrahmanirrahim.
Assalamualaikum warahmatullahi wabarakatuh. Peace be upon you. Alhamdulillahirabbil alamin wa bihi nasta'in wa ala umurid dunya waddin. Wassalatu wassalamu ala asrofil anbiya'i wal mursalin wa ala alihi wa sahbihi ajma'in. Amma ba'du.
Good morning, ladies and gentlemen. Today, on the 19th of March 2024, marks the second day for Faculty of Law and Master of Notary Program of Yarsi University International Short Course 2024, which is entitled The Dynamic of Indonesia Legal System, Challenges and Opportunities in 5.0 Society, with focused discussion of how to draft an effective arbitration clause.
This event was organized to help students to seek the opportunities and challenges in the 5.0 society within the legal aspect, the urgency of legal reform, contract law in 5.0 society, and arbitration in dealing with 5.0 society.
First of all, let us express our gratitude to Allah Subhanahu wa Ta'ala for the endless blessings which allow us to participate at today's event in a great condition. We also convey our sincere prayers and greetings to the Prophet Muhammad sallallahu alaihi wasallam, whose intercession we wait in Yaumul Qiyamah later. Amin ya rabbal alamin.
Before we start, we would like to give our warmest welcome to some of our most honorable guests. The founder of Yarsi Foundation, Professor Dr. Junalis Udin PAK, the chairman of Yarsi Foundation, Dr. Santi Jurnalis, director of Yarsi University, Professor Dr. Fasli Jalal PhD, the dean of the Faculty of Law, Yarsi University, Dr. Haji Muhammad Rian Bakri SHMH,
the director of Yarsi University Postgraduate Program, Professor Dr. Chandra Yoga Aditama SPPK, DTMNH, MARS, DTCA, FISR. The first Vice Dean of Faculty of Law, Dr. Liza Evita Jakfar, SHMHAM. The Head of Master of Notary Program, Dr. Chandra Yusuf, SHLLM, MBA, MMGT. And all of the participants who still have the spirit to catch up with the following agenda today.
Before we move further into our event, let's introduce ourselves as the Master of Ceremony. My name is Kofifa Nur Ambia, and here is my partner,
Marsyani Solia Rahman,
who will guide you from the beginning until the end of today's event.
Ladies and gentlemen, in this morning, we have several agendas to follow. First, the opening of Yarsi International Short Course Program 2024. Second, reading the moderator curriculum vitae. Third, the presentation of the topic How to Draft an Effective Arbitration Clause, which will be presented by our great speaker, Professor Chang Hueting. Fourth, the discussion, and last, photo session.
Alright everyone, before we start our discussion today, let's check out our moderator's curriculum vitae, Mrs. Nanda Octavia. Mrs. Nanda Octavia, Magister of Education. She graduated from Monash University, Australia in 2018. Her research interests are student achievement emotion, students learning emotion, and teacher professional development. Wow, she's so incredible, don't you think, Marcia?
You're right, Kofifa, so incredible. Now, we are coming to our main event, which is the discussion of the topic How to Draft an Effective Arbitration Clause, which will be led by Mrs. Nanda Octavia. To Mrs. Nanda Octavia, the stage is yours.
Yeah, thank you, Marcia and Kofifa. Assalamualaikum warahmatullahi wabarakatuh, everyone. Good morning, ladies and gentlemen. It is my pleasure to introduce our keynote speaker today, Professor Daniel Zhang Yuting. Professor Daniel Zhang is an associate professor of law at Fujian Polytechnic Normal University And he is also the executive director of China Indonesia Business and Trade Law Research Center. Professor Daniel Zhang is here today with us, Alhamdulillah. I saw him, his bright smiles. And let me tell you a little bit about Professor Daniel Zhang's education background. Professor Daniel Zhang earned his doctoral of juridical science from University of Kansas in 2014 and his master's of law from Temple University in 2009. He began his law study in China University of Political Science and Law, where he earned his bachelor degrees in 2003. Amazing work Professor Daniel Zhang has conducted in his research interests, which are international trade law, international arbitration, and foreign investment law. In these fields, Professor Daniel Zhang has published many articles, which some of them, let me share you a little bit some of these articles that Professor Daniel Zhang has published. First is Castle Doctrine under American Law in Journal of Fuqing Branch of Fujian Normal University in 2019. The next one is several issues regarding arbitration clauses in international trade contracts in China Journal of Commerce in 2021. The next work, which Professor Daniel Zhang has also published, is Legal Analysis of Failure to Perform International Commercial Contract, which was published in Journal of Nanyang Institute of Technology in 2022. And the other works which professor has done was legal analysis of the intellectual property litigation in cross-border e-commerce in the United States, which was published in journal Kikihara University in 2022. The last one, it might be the latest work which professor has done. It was major legal rules and compliance path for cross-border enterprise data transfer in financial technology time. I think that's a little bit about selected publication from Professor Daniel Zhang. And without further ado, please join me to welcome Professor Daniel Zhang Yuteng. Professor, it's over you.
Thank you. Can you hear my voice clearly?
Yes. Yes, we can.
Okay. Good morning.
Morning.
Good morning. Morning. Greetings to everyone in the class, and welcome to Yarsi International Short Course 2024. Selamat siang, nama saya Professor Dr. Zhang Yuting, and that's pretty much all Indonesian I can ever speak. Well,
Sounds good.
my name is Daniel, and I'm currently an associate professor in Fujian Polytech Normal University, and I'm also a licensed attorney at an international law firm here in Fuzhou, a southeast part of China. I've been to Indonesia for twice, and the latest one is back in 2016. That's 8 years ago, and I'm looking forward to visit again. It's a beautiful country.
Thank you.
It's an honor. It's honor to be here today. So let me share my presentation, I think. Okay, here. Can you see my PowerPoint slide?
Yep. Yes, we
Okay,
can.
good. Okay, great. All right. So today's topic is how to draft a effective arbitration clause. Well, some of you, especially those who never get involved with international arbitration, might ask the question, why would we need an effective arbitration clause? Why would we even need an international arbitration anyway? Well, to discuss this, we should go way back to dispute resolution processes. As we all know, after two parties sign a contract, things could go wrong. People might get different opinion. So in order to solve dispute, we usually have two major types of dispute resolutions. The first is, we call that consensual processes, such as negotiation, mediation, conciliation, in which the parties attempt to reach agreement. That also means if the party doesn't agree with each other, they could just walk away from the negotiation without any consequences. The other is, we call that adjudicative processes, such as arbitration, litigation, in which a judge, jury, or arbitrator determines the outcome. That means the decision is binding. The party cannot just walk away from the dispute resolution. Among these dispute resolution methods, arbitration is widely adopted in international commerce. And that's because it has several advantages. There are, excuse me, there are several advantages to use international commercial arbitration to resolve cross-border disputes. First, arbitration is often faster and more efficient than traditional litigation. This is because arbitration process can usually be less formal and more flexible than court proceedings, which can be time-consuming and costly. Now, I remember once we have because I'm a licensed lawyer, so once we have to present over 100 evidence to the court, and the court has to review, the both party has to review all 100 evidence, one piece by one piece. Even though some of the evidence, we don't have a different opinion of it. And that's a very time consuming. But in arbitration, it can be flexible. The counsel can ask, do you have, questions? Which of the evidence you have questions on? And we can only review those evidence that both party has question. Second, in arbitration, the party can select arbitrators. And that's quite different from litigation, because we all know that you cannot choose your judge. Well, if the party can select an arbitrator, then somehow they will feel the arbitration could be more informal and reach a more fair decision. Third, arbitration is confidential. It is true, it is more confidential than traditional litigation, because the court proceeding usually goes to public, which means that some of your sensitive information involved in a dispute can be made public. In contrary, arbitration proceedings are usually private, which means that the party can keep the details of the dispute confidential. And arbitration, the final one is arbitration. Arbitration awards are easier to enforce across border than court judgment. This is because most countries have signed the New York Convention on the recognition and enforcement of foreign arbitral award, which provides a framework for the recognition and enforcement of arbitration award in different countries. There are more reasons why arbitration is widely used in international commerce, but these are the main ones. Now, compared to litigation and arbitration, arbitration has one big difference. Litigation is a public procedure, which means in litigation, parties may be compelled to participate in court proceedings. That means when people involved in a legal disagreement, they can be forced to take part in the legal process in court, such as showing up for court dates, giving evidence or documents, and following the court orders. If they don't cooperate, they could face consequences from the court. On the other hand, arbitration is a private process. You cannot compel the other party to participate in arbitration unless you have a contract that requires it. In other words, both parties must consent to participate in arbitration. And that is why arbitral clause or arbitration agreement is so important, because there is no right to require parties to go to arbitration in the absence of an arbitration agreement. You have a right to go to court at any time, but if you don't have an arbitration agreement or arbitration clause, you cannot go to arbitration. Now I use two words, arbitration clause and arbitration agreement. And these are two commonly seen phrases. And in legal perspective, they have the same binding power. The difference is an arbitration clause is contained in a written agreement made by the party, usually before a dispute arises. An arbitration agreement is a separate agreement made by the party, usually after a dispute arises. Now, in very rare cases, both parties might sign a separate arbitration agreement at the time of signing the underlying agreement. However, this is very uncommon. I've been practicing law as a lawyer for 7 years, and I never saw a party like sign a separate arbitration agreement so far. Now, which is easier to reach? That's the question. Of course, the ideal time to reach an arbitration intention is to reach before the dispute arises. Once the dispute is arisen, I would say try to reach arbitration procedure. It's very difficult. Once people have different opinion, they just simply cannot agree on anything. So the ideal time to think about what you want in your arbitration agreement is the same time that you are negotiating the underlying contract. At that time, both parties are still trying to work together to achieve something. And that is why arbitration clause is much more common than a separate arbitration agreement. Now, sometimes I saw people refer to arbitration clause as arbitration agreement. And this is also very common. The two terms are actually, I think they are interchangeable in many books and journal articles. But just to be precise, I will use arbitration clause in this topic. Now, there's one thing you should bear in mind. An arbitration clause is a self-standing agreement. That means it's divisible from the underlying contract and it can survive the termination of the contract. So say you and I sign a contract and the contract contained an arbitration clause. Even if our underlying contract is terminated or we have a disagreement on the validity of the contract, the arbitration clause is not effective. The arbitration clause will survive even if our contract is terminated. The arbitration clause will remain in existence, entitle both parties to start an arbitration proceeding in regarding any claim for damage or any exercise of right arising of our contract, no matter the condition of our underlying contract. And that's why it is a self-standing agreement. Now we know that arbitration clause is important, and now we're gonna discuss how to write an effective arbitration clause. Well, international arbitration agreement can be very short, or I saw some arbitration clause as short as like one sentence, such as English law arbitration, if any, London, according to ICC rules, or arbitration, Hong Kong, China. Now, I would say, I would suggest you not using such short arbitration clause. Although some court would upheld that such arbitration clause is still valid, but I would still suggest you to avoid them. On the other hand, some arbitration clause can be extremely large and extremely long. And I saw a separate agreement contains dozens of pages. That is, of course, a very complicated multi-party transaction agreement. However, a number of issues should be considered in drafting an international arbitration agreement. We will first address some critical elements that I think must be addressed in your arbitration clause. And they are agreement to a binding arbitration, scope of the arbitration agreement, use of an arbitral institution or ad hoc, selection of an arbitral seat, and choice of law. And these elements basically must be included in virtually every international arbitration clause. We will then discuss some other important factors that I think you should be considered, and that include selection of arbitrators, language of the arbitration, allocating legal costs, confidentiality, and sometimes you have to deal with multi-party or multi-contract arbitration. Okay. First, agreement to binding arbitration. it is very important that any arbitration clause must clearly set forth the parties' agreement to arbitrate. You remember that just a few minutes ago we talked about if unless both parties agreed to arbitrate, you cannot force the other party to participate in your arbitration. That is why every arbitration clause must clearly set forth the parties' intention, the parties' agreement to arbitrate. And this means that in the agreement, both parties should expressly refer to arbitration, not mediation, not negotiation, not settlement, not ADR, the alternative dispute resolution, not conciliation, or some form of non-judicial resolution. You have to specify arbitration. And that requirement also means that define the category of dispute should refer to arbitration for a binding or final deposition. The arbitration clause cannot treat arbitration as a possible future option or a possible choice. It cannot say that arbitration will produce merely a recommended choice or recommended opinion, as opposed to a binding enforced award. Let's look at two examples. Here in my slides, I have all disputes may be resolved by arbitration. Do you think that's a good arbitration clause? The second is all disputes may be submitted to arbitration. What do you think? Is that good enough? I saw this kind of, I saw this kind of clauses from time to time, and I suggest you to avoid them, avoid these formulation, because some local court will interpret the use of the word may as providing only for an optional or non-mandatory. It's an optional possibility. Of course, I think this kind of interpretation is incorrect, and many courts will see this as a valid arbitration clause. But it is wise to avoid such formulation and instead use clearly language. So an appropriate drafted arbitration clause should provide it like this: all disputes shall be finally resolved by arbitration. And almost any institutional rules would recommend you to use some sort of a formula like this. Okay, so the second critical element is the scope of arbitration. And that is the category of disputes, of claims that would be subject to the agreement to arbitrate. For example, are all disputes between the parties bearing any connection to their contract should subject to arbitration, or only contract claims should be subject to arbitration? Let's see some formula that are frequently used to define the scope of international arbitration clause. The first is all disputes arising under this agreement. You think that's enough? All disputes arising out of this agreement. Third, all disputes in connection with this agreement. Fourth, all disputes relating to this agreement. Do you see the differences? And final, all disputes relating to this agreement or the subject matter hereof. Okay, now some court, I would say not all court, but some court might distinguish these different formulas. For example, disputes often arise over the question if the arbitration, such arbitral clause would extend to torts or other non-contractual claims. A few court would, a few court would consider the first three, especially the first two courts as strictly contained to contract claims. In other words, if your claim is a tort claim, the court might think your arbitration clause does not contain that. And of course, many more courts would refuse to distinguish this formula. Instead, would interpret this contract arbitration agreement more expensively. But nevertheless, you should bear that in mind and remember to draft your arbitration clause as broadly as possible. And here, this is an example of a very broad arbitration clause. All disputes, claims, controversies, and disagreements relating to or arising out of this agreement, or the subject matter of this agreement shall be finally resolved by arbitration. So, first, it is generally desirable to begin with words like all disputes, claims, controversies, and disagreement. This will reduce the risk of litigation or arbitral proceeding over whether a dispute is involved. Second, the formula should ordinarily be used together with one or more broad connecting phrases, such as disputes relating to or arising in connection with. This is usually to avoid confining an arbitration clause merely to disputes arising under the agreement or arising from an agreement. And I saw an example that in a IP case, there's a patent infringement, and we all know that a patent infringement is a tort, not a contract claims. So in that particular case, the party tried to bring the other party to arbitration for patent infringement, and the counterparty file a lawsuit, and the court actually rejected, and just the court think the scope of arbitration does not contain tort. And third, reference to the subject matter of the agreement are also often appropriate. And that widens the scope of the arbitration agreement and will ordinarily extend to dispute regarding the formation and validity of the underlying contract. And okay, now sometimes there might be claims or disputes that one party does not want to submit to arbitration. For example, sometimes a licensor of intellectual property sometimes to wish to expressly retain the right to seek immediate immediate remedies against the unauthorized use of their IP by licensees to court. And that's actually an incorrect approach. But if you do, be very careful to exclude particular matters from the scope of arbitration. And here is an example. If you do want to exclude a particular matter from your arbitration, with the exception of those claims which are specifically excluded from arbitration. The third element is whether to have an institutional arbitration or ad hoc. Institutional arbitration is one where the parties agree that an institution such as the ICC or SIAC will administer the arbitration, and there are many benefits of an institutional arbitration. In particular, you will cooperate into the agreement that the institution's set of rules, and those rules are well thought. They developed as the institution has seen many types of problems that comes up, and those institutions like the ICC publish their rules and numerous language, and you incorporate those rules into your arbitration agreement merely by reference to the institution rules. And secondly, an institution will administer the arbitration process. And what that means is they will supervise John to the would determine the tribunal fees, and typically they will either provide a fee which depends on the amount of dispute, or an hourly rate for the tribunal. And most institutions will have a cap on the rate that the tribunal can charge. I remember the Singapore International Arbitration Center will charge you 3,800 administration fee and 6,200 Singapore dollar arbitration fee if your case is around the amount of your dispute is around 50,000 Singapore dollar, and that's actually quite a large amount of money. Also, the institution will also hold the deposit and determine when the deposit should be paid, and and remit any balance to the party at the end of the dispute if there's a balance. And finally, the party often don't realize, but the institution have excellent secretary services that the parties as well as the tribunals can contact the secretary if they have questions, and you can even contact their secretary for help even when you are negotiating your arbitration clause. One really important point: if you are going for institutional arbitration, please make sure that the institution actually exists. I once saw an arbitration clause say all disputes should be finally resolved by arbitration in Beijing. Now, there are 2 arbitration centers in Beijing, and that really caused some trouble for the party to start the arbitral procedure. Second, ad hoc arbitration. In ad hoc arbitration, there's no arbitrational organization involved. Instead, the party just pick up an arbitrator to sort out their disagreement without any institutional help. If things go wrong in the process, like if they can agree on an arbitrator, they can turn to either national arbitration law and court for help. And sometimes they will agree to follow certain rules, like the UNCITRAL rules, to guide the arbitration. Even in these cases, they should always name someone to pick the arbitrator if they can't agree and deal with any challenge to them. If parties want to go with ad hoc arbitration using the UNCITRAL rules, the UNCITRAL suggests using this kind of wording in their agreement. Any problem would any problem would or disagreement related to this contract will be sorted out through arbitration following the UNCITRAL arbitration rules that are in force at the time. Now, you might ask me, should I choose between, how do I choose? Should I use ad hoc or should I use institutional arbitration? I would say most people would go with institutional arbitration. Ad hoc arbitration is occasionally considered in commercial arbitration agreement, and sometimes people would think it's less expensive since there are no institutional staff or services to pay. But think about this: without the institution administering, the arbitrator themselves will need to perform some basic administrative function, which might increase the expense. And of course, the institution can step in, take steps to ensure that the arbitrator's fee are kept within limits, etc. Okay. Now, if you do want to choose international arbitration institutions, there are some leading international arbitrations. They are International Chamber of Commerce, International Court of Arbitration, the ICC. The ICC was established in Paris in 1923. The ICC has long been regarded as the world's leading international commercial arbitration institution. Sometimes people will think that the ICC cost is very high, but it is definitely the most popular one, particularly in Europe. LCIA, London Court of International Arbitration. It is founded in 1892, and it is the oldest arbitral body in the world. It is widely regarded by many people as the second most popular European arbitral institution. Singapore International Arbitration Center, the SIAC, it is initially for disputes arising out of construction, shipping, banking, and insurance. But in recent years, the Singapore International Arbitration has broadened its focus to all kinds of commercial disputes. And I know that many commercial disputes between China and Indonesia would choose Singapore simply because both parties would consider Singapore as a neutral site. China International Economic and Trade Arbitration Commission, the CTAC. CTAC is now one of the major arbitration institutions in China, and its office is actually quite close to where I am. Hong Kong International Arbitration Center, the HKIAC, It is one of the Asia's leading international arbitral institution. Historically, Hong Kong has been one of the preferred arbitral institution in Southeast Asia, and the Hong Kong, the HKIAC rules are based on the ancestral rules, with a number of innovations, including provisions allowing for parties to choose how to pay. And last but not least, the Indonesia National Board of Arbitration, the BANI. BANI Arbitration Center is the first and leading Indonesia arbitration institution at the international stage. And I know it's a dispute resolution institution frequently chosen by many foreign investors in Indonesia. Okay. Arbitral seat. Now, a lot of people would say that the arbitral seat is the most important factor when drafting the arbitration clause. And there are three locations may come when in the actual arbitration process. First is the seat of the arbitration. It is the place where the arbitral award will formally be made. The second, place of arbitral institution. It's the geographical location where the institution is located. And third, venue of arbitration or venue of the tribunal. That's the geographical location where the arbitration is conducted. And remember, the seat, only the seat matters. I can give you an example. And so in a hypothetical case, excuse me, parties could choose Singapore International Arbitration Center as the institution, choose the United States as the seat of arbitration, and the arbitral tribunal meets in Bali simply because the tribunal arbitrator think Bali is a beautiful, wonderful place to meet, and that's exactly the case. Okay, so there are three locations here: Singapore, United States, and Indonesia. And Singapore is the place of arbitral institution. United States is the seat of arbitration. Indonesia is the venue of arbitration. Indonesia is the place that the tribunal meets, that the arbitrator meets. And in this case, only the place of United States matters. So the seat of arbitration has significant legal effects. What's significant? Well, first, it means that the arbitration is subject to whatever the national arbitration legislation is in that jurisdiction. So, for example, if the arbitral seat is in United States, then the United States law may dictate some certain result. The United law will have like mandatory provision on your result. And the second importance is that it will affect the ability and likelihood of intervention by the local court. So in the previous case, the United States court will enforce your arbitral award, and you have to get like interim relief from the United States court. You have to challenge the arbitral process in United States. And there are a number of other issues, whether you can challenge a member of the tribunal, can you appeal the award, or can you get an injunction preventing the arbitration from continuing, etc. You have to do that in the seat. You have to do that. And the third And the further important is whether the seat is a New York Convention Center. Obviously, if it's not a New York Convention country, and it will affect your ability to enforce the word if you are successful. And you may ask, what arbitral seat should you choose to specify? Well, I would say you have to consider a number of reasons. First, the seat must be a state that is a member of the New York Convention. And that will ensure that the parties' arbitration agreement and any resulting award will be maximally enforceable. Second, you have to choose an arbitration seat which has like a national arbitration legislation that are hospitable to and supportive to arbitration. And third, the selection of arbitration seat will often have a material influence upon the selection of the parties. If an arbitration is seated in Switzerland, for example, it is likely that one or both parties will consider selecting a Swiss party nomination. And this is something that you would have in mind. And fourth, in some countries, the local law may have a material influence on the subject matters. For example, if you choose China as the seat, remember, the Chinese arbitration law doesn't allow arbitration, ad hoc arbitration, and that means, if you choose the seat of arbitration, you have to choose an institutional arbitration. Now, what if the arbitration clause does not specify a seat? Now, many institution rules will include the default provision, providing a mechanism for selection of the arbitration seat if the parties' agreement does not specify a seat. Okay. Last critical elements, applicable laws. So there are potentially three different laws which can apply to disputes. First, the substantive law of the contract. Now that's the law which determines what the contract means and what the parties' rights and obligation. And second, the law of the seat, and that's the law which determines the arbitral procedure rules governing the arbitration. And thirdly, there might be a third law, and that's the law that governs the arbitration agreement itself. And this is because of the separate nature of the arbitration agreement. You can't just assume that that the governing law of the underlying contract will be the same as that of the arbitration agreement. And it is very possible that the law of the contract, the law of the seat, and law of the arbitration agreement are three different laws. But I would strongly suggest you to write your arbitral agreement to make sure that all three applicable laws are the same law. And remember, the seat of the arbitration law is the law that governs the arbitral proceedings. The seat of the arbitral the seat of the arbitration law is the law that governs the arbitral proceedings. Okay. Now we're going to some other important factors. First is the selection of arbitrators. Well, first, numbers. I know a lot of people would want to include the numbers of arbitrators in their arbitration agreement, and many people will will write on 3 arbitrators will be included. Now, the things to think about in terms of numbers are the complexity of the disputes, the value, the speed. And remember this, if you have 3 arbitrators, it will be much more expensive. If you only have 1 arbitrator, it will be cheaper and quicker. So I once saw a case that 2 parties, they have disputes over only like a few thousand disputes, and then they have to go to arbitration, and they have to use 3 arbitrators because of the the way they write in the arbitration agreement. And that caused a lot of unnecessary fees and expenses. So think about that. And if the tribunal only have like 1 solo arbitrator, it will be cheaper. It will reduce your cost. Second, the methods of selection. Now, it is critical for an arbitration agreement to include some methods for selecting the arbitrator if the party cannot agree upon their identity. The most common mechanism is design appointing authority, so that the institution will select the arbitrator if in the event that the parties cannot agree with each other. And qualifications. You can, if you want to say what type of legal expertise you want, such as nationality, technical expertise, but be very careful, I know an arbitration case where they have requirement with a very specific industrial section expertise, say 20 years in like a oil industry. And it's going to be very difficult to find somebody who met all those requirements and who is willing to be appointed as the presiding arbitrator. And fourth, specifically named arbitrators. Okay, so the parties can agree in their arbitration agreement on the identity of individual arbitrators. And I would suggest you don't do that. Don't do that. Unless your agreement is trying to cover an existing dispute, it is generally not desirable to designate it as specific individuals as an arbitrator in advance. That is because if you name someone as your arbitrator in advance, and he or she might have a conflict of interest or might turn out to be unsuitable for the disputes that arise in a later time. At that time, it will cause you a lot of trouble because you cannot find a proper arbitrator. Okay, next is language of the arbitration. Are you having just a sole language or dual language? Think carefully, because it will it has something, it is related to the cost of your translation. And we once have a arbitration case in Singapore, and my my party could speak Chinese, the counterparty could speak Chinese. The document has tens of thousands of pages that are in Chinese. The arbitrators are fluent in Chinese. Unfortunately, however, the language of the arbitration in the arbitration clause says the language is in English. So my party spent tens of thousands of dollars in translation, which is meaningless. So I would suggest you can specify the language of the arbitral proceeding and award. If you don't do that, many institutional arbitration rules usually expressly authorize the arbitral tribunal to select a language of the arbitration. The next is allocating legal cost. So we know that in international commercial disputes, the legal and the related cost could be as huge as millions of dollars. And the most international arbitration agreement and institutional arbitration rules, the parties are initially responsible for paying their own litigation expenses. And they are also responsible for sharing equally in payment of the arbitrators and arbitral institutions' fees and costs. And in many international arbitrations, the initial payment of legal costs and are subject to subsequent relocation by either the tribunal or the arbitral institution. And under most laws, the fees of the legal cost are paid by the losing party. And that is in contrast to the American rules. Because in America, the American rules, the parties generally bear their own costs and fees. And although that's not a big issue in most cases, parties can adjust this issue in advance in the arbitration clause. There are two ways to do that. One is the direct way, and that the party can expressly specify that the prevailing party shall be entitled to recover its legal costs. Or the indirect way, the parties can grant the arbitrators discretion to award cost of legal representation. Okay. Third, confidentiality. So yes, arbitration generally are more confidential. That's true. The arbitral progress is confidential. The arbitral award will not be published like a court order. However, and you have to remember this, some institutional rules do not cover confidentiality. So you can stop the other party to review information. In that case, a party can only ensure confidentiality through agreement or as provided by the applicable laws. And that's especially important for you to consider, especially in intellectual property cases. I will strongly recommend include a confidentiality clause because we know that there's an increasing push to transparency. And here is a good example of a confidentiality clause. Except as may be required by law, neither a party nor its representative may disclose the existence, content, or results of any arbitration hereunder without the prior written consent of all parties. And remember, even though arbitration is more confidential, without a confidentiality clause, the other party can still review the arbitral award. You cannot stop that. Okay. Last, sometimes we're gonna have like a very complicated multi-party and multi-contract. Well, that increase the complexity because most international arbitration clause and some institutional arbitration rules are drafted with two-party disputes in mind. Use those provisions where three or more parties are involved can bring difficulties. For example, we usually say that each party may nominate one arbitrator, and that's not easily applied to contract with three or more parties with different interests. So a multi-party arbitration should be drafted to ensure that all parties to the underlying contract can be included within a single arbitration, and that the appointment of the arbitrator can proceed smoothly. So, and also, we usually do that by providing appointing authority. We usually to designate the institution to appoint a sole arbitrator or all three members of arbitrator in a three-person tribunal to solve that problem. And if you do draft individual arbitration agreement, be sure to include provisions for consolidation so that it will permit the arbitrators to consolidate two or more pending arbitration among the same party. And that is the same in a multi-contract scenario. And we know that in modern world, many commercial will undertake will involve multiple parties, like project finance transaction, construction project, and joint ventures. So these agreements can raise difficulty drafting and planning issues for dispute resolution. So a frequent used means of a frequent use mechanism is to use a single master dispute resolution agreement or a single dispute clause in a framework agreement. And then even though you have like different parties, different contract, all the contract can incorporate the master arbitration clause by reference that arbitration clause into all of the individual project, and and so that you can design a single mechanism for dispute to solve all multi-contract problem. Okay, I think that's all for today's topic. And here is I put my email in the final slide. If you have any question, feel free to ask me now. If you cannot think of a question, you can always email me about international arbitration or Chinese law. Or if you simply have any question, feel free to email me. And that's today's. That's all. And thank you.
Yeah, thank you so much, Mr. Professor Daniel Jean. Wow, I took a lot of notes. I'm sorry, can everybody hear me?
Yes, I can hear you.
Yeah, thank you so much, Professor. Yeah, I took a lot of notes from your speech this morning. So the focus is international arbitration. I can interpret, and it's quite a lesson. So let me show you a little bit of my note that you suggest us not to confuse between not to get confused between the word of arbitration agreement and arbitration clauses, because clauses should be designed before the dispute happens, and that's to prevent problems. And the arbitration agreement, that's the time that you should address your resolve your problem.
Well, the thing is, these two words, arbitration clauses and arbitration agreement, nowadays people are using them interchangeable. So I think these words are basically the same. But in legal terms, a clause is one part of agreement. So if you say you sign agreement with the accounting party, then and that's a whole big agreement, and you put like a clause in the agreement. That's the arbitration clause. An arbitration agreement in the legal term, it's a separate agreement. Say I sign a like international sales contract with you, and we sign another agreement that's arbitration agreement. And but nowadays people are using this term like interchangeable. I think and I think that, yeah, I think that's basically the same.
Yeah, but it has same binding power. They do.
Yes,
They have same
yes,
binding power.
yes, yes, and
Yeah,
also, it's also arbitration clause. Usually, they draft it before a dispute arises.
right.
A separate arbitration agreement will be drafted after the
That is
dispute. Yeah,
exactly.
and that's a very difficult because if we have like disagreement, then it's very difficult to reach arbitration.
Yeah, so that's why we should have a kind of a prevention to have the clause, and
Mm-hmm.
and the clause should be in the agreement. That's
Yes,
what I
yes,
read.
yes,
And then you have a very note highlighted a very, I think, very critical a critical lesson for us to write our arbitration process. It should be must be included. What is it? Some can be some clauses, arbitration clauses, it can be in one sentence. Some can be larger. Even some institutions have 1,000 pages of arbitration agreement. And but these four agreement in particular elements of the agreement, there are one, two, three, four, five. I note, and you should make sure it's included in your international arbitration clauses.
yes.
Um, yes, Professor, I think we can invite the participants here who are really, I bet that they are eager to ask questions. Please raise your hands, everyone, if you would like to clarify or consult things with Professor Daniel Zhang. Yes, raise your hands. Don't forget to unmute your microphone, and I'll take note of the
I
question. Yes.
Yeah, I saw a question here. Poppy Call has a question. Does arbitration will be the most effective way to resolve problem in business for especially international business? Because currently so many business relation involve international relations and so many complexity in the business field. Yes, I think arbitration will be the most effective way, especially in international business. I've listed several advantages here in my slide, but I personally think the single most important advantage is the enforceable. I will type. Okay, just one second. Let me see here. Okay, enforcement. Okay, enforcement. If you go to a court, say I have let me give you an example. I have disagreement with a counterparty in United States, and I sue him in a Chinese court. The Chinese court like deliver a judgment against my counterparty in United States, and I have to enforce the judgment. And remember, China and the United States, they don't have a judicial cooperation treaty, which means there's no way for me to enforce that the Chinese court's judgment in United States. I cannot do that. So even if I sue a United States parties in China and I won, I cannot enforce it. I can enforce it in China, of course, but I cannot enforce it in United States because there's no judicial cooperative agreement between China and United States. That's not the case in arbitration. That's not the case in arbitration. China and United States are both members of the New York Convention. That means if I got an award from a Chinese arbitration, I can enforce it in United States. I can do that, and I think that's something you should particularly think about in international business, because not many countries has signed the judicial cooperation treaties. Thank you.
Thank you, Poppy. Thank you, Dr. Jacques, for the response. Anybody would like to address one question or two? Yeah, Poppy Cole just said thank you, Mr. Daniel.
Yeah.
We are waiting. We're waiting for others. Feel free to, yes, Detania Sukarja. Yes, Deta, you may ask the question and unmute your microphone. Directly ask to the Professor Daniel. Unmute your mic, please. Oh,
Okay, thank
yeah, we
you.
can hear you.
Yeah, thank you, Dr. Jiang. My question would still be on the enforceability of the arbitration judgment, because as you probably are also familiar that there have been issues on the enforceability of foreign arbitral awards, yeah, even in countries like Indonesia, where one of the parties would still try to use the legal option to try to annul the award, or even still try to find ways to file in court. So what would be your opinion on that matter regarding your statement that arbitration by far would still be the best legal option to settle your dispute? Thank you.
Thank you very much. Thank you, thank you very much, and that's a very good question. I'm fully aware that the enforcement of arbitral award is difficult in some of the countries, and in China too. And my solution is choose the seat wisely, because the law of the seat of arbitration is the law that governing the arbitration proceeding. And if the law and if the law of the seat is a law that friendly to enforce the arbitration award, you will be more likely to get your arbitral award to be enforced by the local court. And and also you have to choose the institution more wisely. And I would suggest you, if you do choose arbitration institution, always go with those with like a they have historically experience to dealing with the those kind of award problem. And even though it might, personal experience, even though there'll still be difficulty to enforce your arbitration award, it's still easier than to apply to recognize and enforce a court judge. That's simply because of there's no framework internationally like the New York Convention. Thank you.
Thank you, Professor John. We have Muhammad Ridwan Erlangga raising his hands. Please, Mr. Ridwan Erlangga, unmute your microphone and directly ask the question to Professor Daniel. You are mute.
Okay, thank you, Ms. Nanda. Good morning, Dr. Jiang.
Morning.
I have several questions. If arbitration was not included in the agreement, is there any chance that the dispute still can be resolved in arbitration court? And second, how appeal process in arbitration court? Is there arbitration court still referring to civil law in both dispute parties? Thank you, Dr. Jiang.
Can you repeat your second question? The connection is not good, so I don't quite follow that. I'm sorry. Can you repeat that slowly? Thank you.
Okay. The second question is how appeal process in arbitration court if we don't accept the decision of the result of the court.
Okay.
And is there arbitration still referring to civil law in both dispute parties?
I'm sorry, the last question is there what?
Is there arbitration court still referring to civil law in both dispute country?
Okay.
In both dispute parties, sorry.
In what dispute party?
In both.
Both.
In both dispute parties.
Oh,
the parties.
Okay. All right. As for your first question, arbitration requires both parties' agreement. So if you don't include your arbitration clause in the agreement before the dispute arises, you cannot go to arbitration. You cannot go to arbitration without a previous existing arbitration clause. Of course, if you don't have an arbitration clause and if both parties still want to go to arbitration, you can sign a separate arbitration agreement. That's possible. I would say that's possible as long as both parties agrees. The second question is if you don't agree with the tribunal's award. There's no court. That's a arbitral tribunal. If the tribunal issues an arbitration award and you don't agree, you cannot appeal it. That's the final solution. That's the final binding award. You cannot appeal it unless there is obvious, clear procedure mistake in the arbitration award. You can challenge it in court, but you cannot challenge the subject matter. You cannot challenge the substantive matter. You can challenge the procedure matter. Let me give you an example of this. Okay, let me give you an example of this. Say we have an arbitration agreement. We have an arbitration agreement, and we take it to the arbitration tribunal, and the tribunal say, I lose, you win, and I'm not happy with it. So I go to court and I try to appeal that. I say, the tribunal made a mistake. I should win the case, and the other party should be the losing party. That's not a proper excuse. The court will not support my proposal, my motion, because that's the subject matter. It's the binding award. You cannot appeal that. The only way that I can appeal an arbitral award is I go to a court and I say, during the arbitral procedure, the arbitration tribunal made some procedure mistake. For example, I didn't get a notice. So when the tribunal has a meeting in Indonesia, I don't know that. I didn't go there. I don't have my chance to present my case to the tribunal. So that's the procedure flaw, and that's the only thing that I can appeal to the court. I'm not sure if I can I answer your question correctly. Generally speaking, arbitration award is final and binding. You cannot appeal unless there is some obvious, clear procedure mistake.
Okay.
And okay.
Mr. Erlangga is happy. Yep. Let's invite other participants to ask questions. Thank you so much, Mr. Professor Daniel, for the response to Mr. Erlangga's questions. Anybody else?
Because I still have a meeting at 11:30, so let's have one question.
One last question. We can have one last question. Well, actually, Miss Detania still raising her hand. So,
Okay.
yeah, we'll just give the last shot to Miss Detania.
Thank you.
Yes, thank you. I had this other question, but I refrained from asking due to time constraints. Thank you for the opportunity. My other question to you would be on the issue on public order as the grounds for the unenforceability of foreign arbitral award as stipulated under the Indonesian law on arbitration. I don't know if you're also familiar with cases like the Karahabodas cases, if you remember. What would be your opinion and your experience so far on this issue, Dr. Jiang? Thank you.
Oh, I'm so sorry. I'm not familiar with the Indonesia law, including the regarding the arbitration cases. So I don't know your cases. I'm sorry. That's not the question that I'm able to answer at this point. But if you email the case to me, to my email address, I will be more than happy to reply that to you. Is that okay?
You're mute. I think she says okay. She says okay.
Email me. I'm sorry. Email me, please.
Yeah, she goes mute.
Okay.
Yeah.
Because I'm not familiar with the case you just mentioned, so I'm not feel comfortable to respond to your question at this point. But
Maybe
please,
generally, doctor. So, I think under some national laws, including under Indonesian law, there's an article saying that a foreign arbitral award is not enforceable when it violates public order.
Oh yeah. You mean public policy, the public policy.
Yeah.
Public policy. Okay. That's a good question, but that's the same case in China too. I know a lot of I know actually I handle a case in China that the other party successfully overturned the foreign arbitral award in the court in the name of public order, a public policy, and to be honest, there is no better solution for me. I don't have like a better solution to avoid the courts, the tendency to overturn the to rejection of enforcement of the foreign arbitral award in the name of public policy. And we call that how to say Chinese social morality in the name of, but we don't have like a better solution. And what we do is we sometimes we will choose like the law of the seat of the arbitration in a, I mean, friendly nation, and so that we will try to enforce the arbitral award in that jurisdiction, in that friendly jurisdiction, to avoid this problem. But honestly, in China, we have the same situation, the same problem, and um, well, Indonesia again. I don't have the position to evaluate the attitude of the Indonesia court because I'm not familiar. But China, I would say the Chinese court used to be not supportive and not friendly in the past years, but recent years, we saw a more transparency. We saw a trend of a more supportive attitude, but still, generally speaking, the that's also my personal experience. The common law jurisdiction, the common law legal jurisdiction is more.
Question,
Thank you,
the
Dr.
challenging question. Thank you for Poppy, Ridwan, Erlangga for asking the question, for being so participative in our morning session today. Because Professor Zhang has another occasion afterward, so I think we'll just close this session by saying Alhamdulillah, Alhamdulillah. I hope that everyone who's joining the session get the benefit of coming to the session. And thank you, Dr. Daniel Zhang, for your time and explanation on this international arbitration clause. And I think we could just close it. Thank you, everyone. See you and bye bye. And see you
Bye.
in another
Thank you.
occasion.
Thank
Thank
you.
you.
Bye. Thank you. Bye
Yes,
bye.
let's get it. Yeah, let's get it over to the master of ceremony.
Thank you, Mrs.
Yes.
Nanda. Thank you, Professor Zhang, for sharing your brilliant and sharp knowledge within our main session. And huge thanks to you, Mrs. Nanda Octavia, for leading our main agenda this morning.
And now, we finally reached the final agenda of today's event. And to mark the ending of our short course today, let's capture our time together by having a final photo session. So for all the audience, please turn on your camera. Is everyone ready?
Ready?
Say cheese.
Cheese.
Okay, thank you everyone. One more. Say cheese once again. Next slide.
From the deepest depth of our heart, we would like to kindly apologize if there are any mistake or inconvenience in the execution of this event. I am Marshani Solia Rahman and my partner.
Kofifa Nurambia.
As a Master of Ceremony in Yarsi International Short Course Day 2, would like to say goodbye for today.
Thank you so much for keeping up with each agenda today, everyone. While you enjoy your rest, we wish you a very good day ahead.
Wassalamualaikum warahmatullahi wabarakatuh.
Bye.
Bye bye. Thank you. Bye bye. See you.